call our final case of today is case number 167643, Warren Consolidated School District versus the School District of Hazel Park. A mini oral argument on the application, 15 minutes of argument for both sides. Again, counsel for appellant, if you would like to reserve time for rebuttal, you may do so. And keep track of it yourself. But when you're ready to proceed, go ahead.
Good afternoon. May it please the court. Nathan Cusack on behalf of Appellant Warren Consolidated School District. This time I would like to reserve 3 minutes in rebuttal. This case is a lot like the movie Groundhog Day, where no matter how the facts and circumstances change, the result is always the same. We're here today hoping to change that. For over a decade, Warren Con has been trying to stop the school district of Hazel Park from counting in membership and educating Warren Con residents without its permission in violation of the State School Aid Act. By doing so, Hazel Park's actions have caused Warren Con to lose over $10 million in state funding since 2008. There's a history of this case that is crucial to understand why the Court of Appeals and the Circuit Court's decisions in this case were improper. Back in 2014, backing up even further, in 2011, Warren Con filed a claim for declaratory relief against Hazel Park. In 2014, the Macomb County Circuit Court entered an order granting summary disposition in favor of Hazel Park that found that there was a rule that existed with the MDE for challenging various audits that they conduct, and that Warren Con had not exhausted that administrative remedy. In particular, the Macomb County Circuit Court cited specifically MCL 264 in its opinion and order, and in the footnote, it bolded the fact that, stating, an action for declaratory relief may not be commenced under this section unless plaintiff has first requested the agency for declaratory relief and the agency has denied the request or failed to act upon it expeditiously. At various times throughout this case, Hazel Park has taken issue with the fact that Warren Consolidated did not appeal that 2014 order. But Warren Con didn't have to. Two things were going to be true. Either Warren Con was going to seek a declaratory ruling from the state superintendent and it would be granted and it would get the relief that it was asking for, or it would be denied or hear nothing. If that were the case under 264, the statute that its claims were dismissed under by the circuit court, Warren Con was then free to return to the circuit court and commence an original action for declaratory relief. There was no additional requirement that they exhaust any administrative remedies beyond that. And so,
Counselor, can you identify for me what the rule is, and the fact that you're challenging a rule, is that law of the case based on that initial lawsuit, or is that open, subject to debate?
So I think the Macomb County Circuit Court in 2014 treated the review process under the Michigan Pupil Auditing Manual as being a rule that was subject to Section 64. I think it has never been argued or determined in the case whether or not that particular process is, quote unquote, a rule. I think it's more than likely, under the court's recent articulation of what a rule is, I think it probably is a rule, but that has not been determined in the case. So what Warren Con did then was it did what the circuit court told it to do. It requested a declaratory ruling from the MDE, and it received a response from the assistant director for audits, which declined the request for declaratory ruling because, quote unquote, the request for declaratory ruling seeks to circumvent the department's policy that there is no review available for one district to file an appeal regarding another district's pupil membership count. At that point, Warren Con had done what Section 64 requires. It had satisfied the condition precedent to an original action in circuit court. It had asked for the declaratory ruling. It had been denied. So in 2017, we returned to the circuit court with a new complaint, an original action, and the circuit court sent us away again, dismissing the claim because we didn't request that the state superintendent grant a declaratory ruling. So Warren Kahn went back and did that again. We asked the state superintendent for a declaratory ruling. The declaratory ruling that we got was, again, a declination. He declined to issue one for the very same reason as the assistant director, which is the fact that one school district, Warren Kahn, does not have the ability under the rule that has been identified to challenge the audit results of a different school district. That's simply not what their rule allows for. There's no remedy there at all. So with that decision in hand by the state superintendent, we thought, okay, we've satisfied Section 64 now. We're going to go back to the circuit court. We're going to file an original action for declaratory relief. We did that in 2020. But that's when the script got flipped, so to speak. We had been talking this entire time about Section 64. But yet, when we went back to the circuit court in the 2020 case, our claim was dismissed again, this time under Section 263, which is a very different section than 64, and it was entirely improper for the circuit court and for the Court of Appeals to dismiss under 263 for numerous reasons. The first of them.
So let's assume I pretty much agree. Let's assume I agree with you that it was incorrect, and you got this letter saying we're not going to deal with this, and you didn't have some obligation to exhaust remedies or appeal, that non-decision. So you're then under 264, arguably, seeking relief from the courts. Didn't you have to name the MDE as a party also?
That's a very good question, and I 100% agree with you. The issue there is that we didn't really have the opportunity. When we returned in 2020, we were met immediately with a motion for summary disposition. That nothing else happened in that case. It was immediate cross motions for summary disposition right out of the gate, with Hazel Park arguing that because we did not appeal the state superintendent's determination to the circuit court, our claims were now barred. So we never got to the point of naming the MDE. The fact of the matter is, if the orders are reversed and this matter is remanded, it's a procedural matter of adding the MDE as a necessary party as provided for in the statute, and that's something that we would certainly undertake to do.
Thank you.
As it pertains to the problems with Section 63, Section 63 is interesting because it's discretionary on its face. You can request a declaratory ruling, but it does not require any administrative agency to actually give you a declaratory ruling. And it's interesting because it also refers to declaratory rulings. It doesn't say that the absence of a declaratory ruling requires an appeal to circuit court. It says declaratory rulings. The language of 63 is very different from 64. 64 talks in terms of being denied a declaratory ruling or having no action taken on a declaratory ruling. Had the intent in Section 63 been to make it so that the denial of a declaratory ruling was itself a declaratory ruling, Section 64 demonstrates that the legislature knew how to craft that statute, and they didn't do that. It was sort of an affirmative statement that if you get a declaratory ruling from the agency and you want to appeal, you can appeal to circuit court. That sort of then brings the problem that we talk about in our supplemental brief of the Human Rights Party case, which is a pre-1990 case that decided and expressly acknowledged that the language of the statute did not support the decision it was about to reach, but said that an agency taking no action on a declaratory ruling is essentially itself a declaratory ruling that requires an appeal to circuit court, which is somewhat confounding because by the very nature of the interplay between 264 and 263, if I request a declaratory ruling under 264 and I'm properly denied, therefore I can get an original action in the circuit court, relating that over to 263 somehow still means that I then have to appeal that denial to the circuit court, which makes no sense whatsoever. There's not supposed to be that connection. It wasn't supposed to be that you were not supposed to have to appeal not getting something. The other thing to note in that regard is I believe it's the Huron Valley case specifically talks about the fact that in the absence of a hearing or a right to a hearing, there can't be a declaratory ruling. Everybody agrees the MDE does not afford those who make requests hearings. Warren Conn had no right to a hearing before the MDE. We had no right to have a determination of what the facts were, which is important because one of the elements of 263 is that, unlike 64, it applies to a quote-unquote actual state of facts. We don't have an actual state of facts in this case. We have a 100% disputed state of facts in this case. Warren Conn alleges that Hazel Park improperly counted students 1,436 times over the span of about 10 years. Hazel Park claims they were dropouts. Some kids as young as 6 years old, they claim that they were dropouts and they were allowed to claim them. Warren Conn disagrees. That's not an actual state of facts that falls within the ambit of 263. It's most often, typically speaking, if you request a declaratory ruling from an agency and they disagree with your facts, they're just going to deny you the declaratory ruling. And that's actually what the state superintendent did here. One of the other reasons that they declined the request for declaratory ruling is that, quote unquote, there are questions of fact regarding the circumstances of each involved child that are not appropriate to be resolved through the declaratory ruling process. The superintendent recognized that 263 requires an actual state of facts, and there is not an actual state of facts to base a decision on, which is compounded by the fact that we don't get a right to hearing. There's not an opportunity to sort out that dispute during the administrative review process, and so if you are then forced to go into an appeal, you go into an appeal with disputed facts, having resolved nothing and not having any more evidence than you had in the first instance, which essentially just denies the requester due process. And I think the other thing that I would touch upon is, with 63, it also requires that you have to be an interested person, quote unquote, under 63. There's an irony here that the Circuit Court and the Court of Appeals wanted to rely on Human Rights Party for part of its opinion, but they ignored the part of the opinion that talks about the standard for whether or not you are an interested party. The standard under that, if you'll bear with me, is, so under 63, the court stated, we agree with this analysis, and to apply to this case, we find both judicial review provisions essentially require petitioner to show a direct effect on his legally protected interests. The Court of Appeals decided, well, we're going to apply part of Human Rights Party, we're not going to apply that. We're going to apply some unpublished case law, the foreigner decisions from the last few years, which is a lesser standard than what you find in the Human Rights Party case, because that standard merely you have to be affected by a rule. It doesn't talk about it in terms of a legally protected interest. But the importance is I think, clear here. Warren Conn doesn't have a legally protected interest vis-a-vis the rule at issue in this case, because the state superintendent has already stated the rule doesn't cover you. You don't have an option under this rule. They have no interest for you to protect by way of that rule. And there's another point that I would make is that we're talking about claims in each school year. From 2008, these contracts ran all the way up through 2023, the last we knew of them. It's a lot of school years. These membership auditing manuals, they get amended every year. Beginning in about 2019, the auditing manual was amended to clarify that the only review available under the auditing manual was for adverse audit adjustments, meaning Hazel Park submits its membership count, an ISD auditor comes in, looks at the numbers and says, we think you counted these students improperly, we're going to take those out of your count. Hazel Park gets that adverse audit adjustment, then it can appeal the adverse audit adjustment. Warren Conn can't appeal that adverse audit adjustment, and in fact, Hazel Park never received an adverse audit adjustment for any of the periods at issue in this litigation. It's simply, but neither the Circuit Court or the Court of Appeals wanted to grapple with this idea that we were dealing with many, many school years across many amendments of these manuals where the rule changed over time, getting progressively more clear. that Warren Cons simply had no remedy as provided for in that rule. So there was an argument to be made we shouldn't have even had to go down that road in the first place, but we did go down that road. Macomb County Circuit Court in 2014 treated it as though it were a rule. And if it's a rule, and I think it is, then we did what we needed to do, and we have an original action. We should have been allowed to have an original action in circuit court naming the MDE to try to finally get some relief from really actions that may still very well be going on to this day in terms of the taking of Warren Con students. Is there any other questions? Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court, Thomas Land on behalf of the School District of the City of Hazel Park. I'll be brief, but this case is about preserving the boundaries of administrative discretion under the Michigan APA. The gist of Warren Consolidated's claims is they want money from Hazel Park for students they did not educate. The MDE awarded Hazel Park state school aid funds based on membership counts that were approved by the MDE. The first important point in this matter is that there is no dispute that the Michigan Department of Education is tasked with determining student membership counts. The Department of Education maintains oversight over the approval process. The lack of their presence in this dispute is fatal to Warren Consolidated's claims. When Warren Consolidated chose the route in pursuing its claims directly against Hazel Park, the trial court correctly dismissed their claims. Essentially, Warren Consolidated seeks to stand in the shoes of the Michigan Department of Education, circumvent their authority over student membership counts, and asks the trial court to have an award of in excess of $10 million to Warren Consolidated for students it did not educate. This court raised two interesting procedural supplemental questions under the APA. It's likely that both of these options could have been available to Warren Consolidated to pursue their relief. The problem is Warren Consolidated chose not to pursue either of those options. I do want to address something Warren Consolidated's counsel said, is that they would name the MDE in any action. The problem is this has been going on since 2011, and they have not once chosen to identify the MDE as a party to the action. They have not challenged the MDE's membership counts. They have not challenged anything that the MDE did with respect to Hazel Park student counts. Ultimately, the reason we continue to proceed in this case is because their claims in this regard, without the MDE, have no merit.
So counsel, let's go back to 2011. What should Warren have done?
After 2011, Your Honor, Warren Consolidated should have brought either an appeal of the decision of the MDE under MCL 24.263, or it should have brought a direct action against the Michigan Department of Education challenging the student membership counts. It chose neither option and instead brought monetary damage claims against the city of Hazel Park for students it did not educate. They didn't challenge it from an injunctive standpoint. They're asking for monetary damages in the trial court. And the reason that the case keeps getting dismissed is because it's procedurally improper. And it's likely, if we get down to the substantive issues, it's likely the claims have no merit as well.
So counsel, I found Dean LeDuc's treatise interesting on trying to help sort of clean up this distinction between 63 and 64. He made the point that requiring someone to appeal, I'll I'll just call it a non-decision, I realize the non-decision was a decision, but the failure to like decide the merits, that would then force a circuit court to potentially remand it back to the agency for fact-finding, because obviously they didn't have a record, and then that's forcing the agency to do something that the legislature gave them discretion to not do. So I'm just wondering what your thoughts are on that.
You know, I read that treatise as well as preparing for today's oral argument. I found it interesting that, you know, the way 63 and 64 read together, it could create some level of confusion. I do think that a proper result could have been for the trial court to remand it back to the MDE and, you know, challenge the membership counts in that fashion. The MDE is the party that's tasked with the authority to control these membership accounts. They paid out that money. They paid it to Hazel Park. Warren Consolidated, if anyone's getting the money back, it would have been the Michigan Department of Education. However, they're not sitting here saying your membership counts were wrong, you shouldn't have counted those students. They paid based on that. And at the end of the day, for a trial court to turn around and award Warren Consolidated $10 million for students that didn't educate, they would be making a significant profit in that regard.
Counselor, I think Brother Counselor was suggesting that they could, if it was sent back, amend their complaint and add MDE as a party to this suit. Why is that not a viable option?
Your Honor, the reason it's not a viable option is because they had plenty of opportunities to do so before, and they have chosen not to. They can go back to the trial court and make a motion to amend their pleadings to name the Michigan Department of Education as a defendant in this action, because essentially they're challenging the MDE's decision-making with respect to membership counts. So they would have to go back to the trial court and file a motion to amend and analyze the ability to amend to add them as a defendant. Now, they wouldn't just be added as a, quote, as counsel pointed out, a necessary party. I believe they should be a defendant in this case, and they should be someone that answers, we approve these membership counts. We reviewed the records. We have, there's the pupil accounting manual that has changed over the years. We've used these records, and everything has been approved thus far, so if there has to be a challenge, there's guidelines under the statute and under the accounting manual that they would challenge it with respect to that. So just to simply put them on the pleadings wouldn't be sufficient, but again, we would go down to the trial court and, you know, they could file their motions with respect to amending their complaint. I do want to point out some brief, you know, I think it's important from as we've talked about the presence of the Michigan Department of Education and standing behind the decisions I think it's important that from a policy standpoint, that uniformity in school aid administration just depends on leaving these disputes with the Michigan Department of Education. Not scattered among trial courts with different schools suing different schools, districts. This issue should stay with the Michigan Department of Education and not the circuit courts. The Michigan Department of Education should continue to analyze these student membership counts as opposed to trial courts across the state making different determinations with respect to the student counts. If every school district could bypass the Michigan Department of Education, there would be a variety, could be a variety of inconsistent rulings with respect to membership counts across the state. So for those two policy reasons, I believe that this court should affirm the trial court and the Court of Appeals and find that Warren Consolidated's claims against the school district of Hazel Park were properly dismissed for lack of subject matter and affirm those courts. Unless the court has any other questions, I intend to rest on my briefs.
No? Thank you. Mr. Officer Pachusek, you have 10 seconds. Take your shot.
Yeah, just to push back, our complaint is not principally about money. It is about declaratory relief to stop this pattern and practice for the last decade from occurring. Are we seeking some money damages potentially? Yeah, but this is primarily declaratory relief. Thank you.
Counsel, luckily I'm asking you another question, so you get to stay up a little longer. Tell me why Brother Counsel is incorrect, that you could have added the MDE earlier. I know you spoke about the most recent time and, the motion for summary, but sort of like how this procedurally, why they were never added.
I think the simplest answer to that question is they weren't added in the 2011 lawsuit, because with the 2011 lawsuit, that went up to 2014. That was when the opinion and order came out, where the court said, no, it's 264, it's section 64. You need to at least go ask for the declaratory ruling before you can maintain an original action. So go do that. And then when you come back, that's when the statute triggers about naming the MDE. When we came back in 2017, we sort of knew where this was going again. 17 and then in 20, we never got past jurisdictional issues. It was always a motion. It was always a motion for summary judgment or disposition under C4 for lack of jurisdiction. The MDE didn't miss out on anything other than nonstop jurisdictional fighting while Warren Conn attempted to finally get its day in court. They didn't lose anything. There's nothing that prevents us from adding them now. They won't be prejudiced in any way by not being a party to any of these things. We think that is a very easy technical correction that can be made.
Thank you.
Thank you.
The case will be submitted, and the court will stand adjourned until tomorrow morning. Thank you.